Oh, thank you very much. There's a hashtag for you, hashtag TDW, that difficult one. Well, you know, that's fine. If I've earned that reputation at times, is a good thing to me. I think that if you want to change the future, then the way to do that is not to accept the status quo and, you know, to be the change that you want to see. So I think that's the only way you're going to do that is to be a bit challenging at times. Now, I would be able to read my notes if I put my glasses on, which is great. So thank you, David. Thanks for that great session. I really enjoyed that. Now I'm sort of going to switch hats a little bit. I have to do this. I can't see my notes like that, but then I can't talk to, can't see you otherwise. It's slightly going to switch hats in terms of now putting standing in the shoes of the smaller companies and the innovators and how they engage with corporates. We've heard a lot from the corporates, which I thought was fantastic. There's some great work going on, and I think that, you know, we can engender even more. I'm going to be doing this, it's going to annoy me and you. The session, though, is going to deal with that sometimes very complex and tricky subject of intellectual property. And in open innovation, dealing with IP, it's going to be even trickier. Of course, some of that already came up when you're dealing with external innovators who are involved in disclosing what is their precious cargo to third parties. So following on from the previous session is the whole theme of trust. That came into David's top three. So this is very much our focus, that engendering trust is key. And I think it's one of the biggest challenges, personally, in open innovation. One of the core reasons for that is the fact that innovation concepts themselves are not actually protected by copyright. And I think a lot of people make a wee mistake there of putting at copyright. I'll check if I put it on my slides. At copyright and thinking that actually protects the main core idea when it actually doesn't. And I won't go into too much of that detail because I know that Joran is going to take on that subject. So, but that presents an interesting issue. As we said, without the conversations and collaboration, innovation isn't open, actually. It's merely a jar. And I hope people agree with that theme because I've used it throughout. So the lack of concept protection causes quite a number of problems. Firstly, creative firms, innovators, inventors, they rarely want to create and run new companies. They're happy doing what they do, which is ideation, creating concepts, whether that's on behalf of client organisations on a fees for services basis, or whether it's developing their own stuff that they then want to license into industry. So in order to do that, they need to have conversations, they need to collaborate, otherwise if they can't have those conversations and collaborate, there's nothing to bring to market. And in order to collaborate, they need to disclose concept work to facilitate that. And to do that, there needs to be a less complex, or non-complex, I should say, and safe means to disclose. Because when you are a creative company, you know, going through the traditional intellectual property mechanisms of whether it's patents or design registration at conceptual stage is not only too early, but it's also too costly. And so and if you're generating ideas on an everyday basis, what are you choosing to protect and copyright before you can have those conversations and which direction you're going to go in? So, okay. So I can imagine, I was surprised that non-disclosure didn't actually come up at all in the earlier session. And a lot of people say, well, you know, people want to share ideas, then you can sign a non-disclosure agreement. Simple. But actually, with non-disclosure agreements, often corporates can't enter into non-disclosure agreement because for fear that what they've signing up to might actually contaminate their own intellectual property. NDAs are often standard and generic. You can download them for free off the internet, or somebody will produce their non-disclosure agreement, which has terms in that suits them. And if you want that to be non-standard, before you can even have a conversation, you've got two sets of lawyers involved. Sorry about the lawyers here, pushing your fees right down. And another key thing is that non-disclosures don't actually show what's being disclosed. It's, you know, they can be quite robust, but at the end of the day, what has been disclosed, it just tells you what you're not to disclose information to other parties. And quite often it can get, during development, it can get forgotten as new disclosures, progress things. NDAs also don't protect the core idea. And if those that are running open innovation competitions, are they going to have the times means to enter into what might be hundreds of different participants and individual contracts? No. So we need something that will work for both parties and protect both parties. Now, I've picked this because Mike is here, and I have cleared this with Mike, it's fine. But what I want you to do as the corpus is to stand in the shoes of the innovator. Let's say, sorry, you can't hear me, I'm wondering Mike's not gone. So, if you're in the shoes of the individual, the innovator, and you don't know Mike, we know how lovely Mike is, we know we can trust Mike, but if you don't know him, and you go to the Open Ideas Connect portal, because you want to present an idea to P&G that you think is going to make them a lot of money and make you a lot of money, and totally transparently in their own terms and conditions, will P&G sign a confidentiality disclosure agreement? And they will, but only after they've reviewed your idea, and they'll consider it. But this doesn't mean to say that, you know, there's anything wrong with P&G. They've been totally transparent. But if you are an innovator, an individual, an SME, even a university, a PhD, to you, that's a great big organisation, and you're the little guy. It's a David and Goliath scenario. And so the only thing we do is to engender trust between the innovators and the corporate giants. And I think that's one of the things that it did actually come out of this morning's session. And if we don't do that, again, without the conversations, then open innovation is going to remain merely a jar. So I'm going to just give you a quick run through of my three speakers, and they can take this subject further on. So I'm going to just give you a quick biog overview, and I'm going to do that in reverse speaking order. So starting with, we have Paul Mellor, who's Design Director of Mellor & Scott, and here to represent the creative industries. Yaha. He's a director of a London-based full-service design agency. He's worked in the creative industry for 8 years, and he's earned himself a reputation for producing compelling creative work. Did you write this, Paul? For organisations such as River Island, Unilever, that's it, pick the speakers, Unilever, Ray-Ban, Bank of Canada, and P&G. And he tells me he's got a perfectionist eye for detail. So if anyone spots a typo in his presentation, I'm definitely going to give him a prize. Paul's going to be presenting on the value of creativity. He is going to be followed by my second speaker, who is Donald O'Connell. In case his name didn't give it away, I can confirm Donald's graduated from the University of Limerick in Ireland with a degree in electronic engineering. His career includes 21 years spent at Nokia in roles that included VP of R&D and Director of Intellectual Property. He runs his own consultancy, Chorlton Innovation, and he's providing services to corporate firms and universities such as Imperial College, where he's also a visiting professor and teaches IP management and open innovation. Don't know where he gets the time, but he's written 3 books, and they are Harvesting Innovation, Patent Factory, and a new one just out on the subject. Is that not published yet? I thought your new one was published. Oh, well, better get on with that one then, on the subject of buying and selling patents. But what he's done is brought us a couple of books, which I will give out as prizes to the 2 best questions that are asked later. And actually, you'll even sign them, won't you, Donald? Excellent. Okay, right. Without further ado, then I'm going to just give a quick biog on Joran, and then he's going to come and talk to you. And he's up first. He's my king of controversy. He's a trilingual trained lawyer, so he can sue you in 3 languages. He qualified in civil and common law jurisdictions and has acted as general counsel for larger and smaller technology companies. He runs his own practice, specialising in strategic solutions for integrating technology, IP. He's opening today with his opinion on why the copyright system is broken.